The Uganda Law Society, Mr. Mukasa, is a sham. It's not. It's not a law society or a bar association in the strict sense. It does not have regulatory authority, supervisory authority, disciplinary authority. It doesn't even admit lawyers, and it doesn't exit lawyers. And therefore, it cannot fully be a reliable broker for you, marketer for your service, because it's just a club. In fact, you can even call it a prison. This thing is the captured entity. It is still in the frame it was presented as a government bar in 1955, when Governor Cohen needed to control the young Turks, as they called them, Abu Mayanja, Beni Chiwanuka, the young Turks from Uganda who were disturbing him. What do I do for them? Let me write a bar act so that they are now subject to the hegemony and dictatorship of white lawyers and Indian lawyers. That's it, and we have never come out of that. So it was written not as a bar association, as you know, any bar association in the global north and even in the global south. All our colleagues have made reforms to say, look, the black bar, the Asian bar is different from the white bar. We should create parity, and they rewrote laws, you know. But in Uganda, our attorney generals, our government lawyers have never been honest, sincere, and patriotic and dedicated to the common man. They continue to serve a government that has the same objectives as a colonial government, irrespective of the reforms and, you know, that we have had, critical junctures, independence, and what, and so on. No, the government lawyer still thinks that the purpose of a government lawyer is to obstruct, deny the citizen rights, and ensure that the government is the monopoly of obstruction. So that's it. So we can't help you much. I sit in the FIS structures. I thought Amanyire has left, and I can't help them. They're doing so much. Uganda is really state. One of the reasons is the legal profession is not not clearly, transparently regulated. When they check, they say law council and the, you know, the global committees, the FATF. What is law council? They say no, it must be law society. And then, you know, there's a lot of confusion. And even many Ugandan lawyers don't know this because they don't know the UN basic principles for the role of lawyers and the IBA standards for independent legal profession, which were set in 1990. They don't know that an independent bar is in charge of, one, legal education. And so it will be the law society that is accrediting universities. But in Uganda, it's a law council, a national council, education. No, it should be the law society at legal education. The law society must then want to, you know, assess the outcomes of legal education, which is the one in charge of entry. So if there's to be a pre-entry exam, what is a bar exam? So the bar exam, not the bar council, law council government exam. So the bar exam to enter the bar. So the bar must be in charge of admission exclusively without interference. Then the bar must be in charge of everything while you are at the bar. So we are still captured, Mr. Mukasa. And the government does not then want to do for you the job you want to ask us of us. They can't chase lawyers. And the government, the law council cannot start saying, the law council act, the Advocates Act doesn't give law council the power to impose the professional indemnity, because then it will be, we shall challenge it. We shall say, who gave you the authority to impose these things, you know, on us? These are things we're supposed to, this is the contract. It's a contract. Why do you make certain contracts? Where? How? How do you make this contract compulsory to us? So your contract is voluntary, under Uganda law because we have never we have no means of resolving ourselves and say, convincing ourselves and say now let us accept this as a condition of practice voluntarily, and then we pass it as our law through our lawmaking authority like all other bars. So we are here in this nonsense, and it has cost us a lot of money in terms of attracting new clients, retaining clients, recovering from client disputes. You go to law council, they have all these problems that would be solved if there was professional indemnity. There's a backlog of problems there, which would be solved by professional indemnity because we were complaining about money. On this very point, just across the border in Kenya, there are ongoing interviews for the Judicial Service Commission. And one of the things we learned from those interviews is that so many people who are confident, capable, and credentialed refuse to apply or participate in the Judicial Service Commission process because they are not familiar with the digital, or they are extremely fearful of the digital interaction, accountability in the digital format. So when they put out an advert for judges, for those who want to be judges of the Supreme Court, because there's now a vacancy, only 6 people applied, 4 of them being judges of the Court of Appeal, 2 of them being women that nobody knows. The media couldn't even find their photos. And so you say, where are the others? Well, when you say the data is that, in Uganda, judges fear. They don't want accountability, transparency, because they fear the digital. There's a judge who wrote a judgment, Justice Irene Munyagonja, saying, no, we will reject you people forcing us to do digital because we fear memes. We don't like to be memed, become, so on and so forth. So we shall keep our judicial recruitment processes behind the curtains. And that's her thinking in 2026. She thinks this process is stoppable. Yet when she lost her husband and she wanted to cry at the vigil, she knew she was speaking in the digital, and you also her tears go viral about Morago. Yeah. So there's a lot of hypocrisy within these old gatekeepers, but we are killing them and burying them. And I thank you for celebrating this experience with us. I want to make a point to our comms team, but this we can keep for in-house, keeping. We need more. We need to push more to energize when our visitors come. We need to push more because we can't rely now on legacy media, the journalists, the camera, taking. No. We have now archives, and we must become the journalists. And I thank you, Ruth, for saying that this has inspired you to write an article. We should be the ones now in the iCitizen, iJournalist. We should be the ones that are in control of our diffusion. We should be able to have future discussions. You cut away. The thing I want to add on, so that's one you've had, comms team, colleagues, lawyers here who are participating. Continue. The third point I want to put on record is the element of public participation. Louis Namwanja Kizito in particular, I have heard you speak very clearly about the fragmented responses of regulators and so on and so forth, and very, very, very eloquently. But Louis has always complained to us that, Isaac, I like carrying water for the bar. I go to Parliament, I put in a lot of research, I submit memoranda, and nobody reads them. I come up with draft laws, and nobody wants to consume them. I write op-eds. I don't feel the engagement from the horizontal power. I have had a discussion with my brother Louis, and the invitation is still open. That Louis, allow me to teach you what we learned from social justice called horizontal power, horizontal organizing, where we don't wait for those who have formal structure, official power. We disrupt them. You're a disruptor. But at the same time, you very much want to be received, with a red carpet by those who hold official formal power. But they fear you. You have a facility with this information which they fear. They don't know digital assets, virtual assets, blockchain technology, but they have the job. So they think maybe you're a threat to their job, maybe so there's a cultural dilemma that blocks your genius and prodigious talent from being well received in a backwater economy like ours, which is disgraceful, but it's something to think about. So Lewis has made me aware as leader, head of the bar, that we need to focus on advocating for public participation law, so that public participation in decision making at all levels of government is not merely voluntary, discretionary, but it's a matter of law. I think in Kenya, that was one of the hallmarks of their 2010 constitution, and it has been the hallmarks of their constitutional litigation, and it has been one of the hallmarks of their constitutional jurisprudence in the last 15 or 16 years now. The High Court has said public participation is compulsory, important, strict, and they have nullified many acts, including in 2023 and 2024, the Finance Acts, for lack of public participation and so on and so forth. And if the courts hadn't done that, there would not be a mandamano. People wouldn't feel that we are one Kenya. So in Uganda, we are still backwards on public participation. In fact, we have the very bad decision of Malema Vidiza versus the Attorney General, both at the constitutional petition of 2017 and the constitutional appeal of 2018 that you know as the age limit dispute, the age limit case. Please take my brother Louis and colleagues, especially those coming from the regulator, Denis Kizito and Emmanuel Amanyire. Of course, the departments you represent are some of the best. They're some of the best regulators that take public participation seriously. And please take this to your executives. We thank them. Capital Markets Authority, yeah, of course, Louis has higher standards for you. But for those of us who see others, you do well. You do well. And so does FIA. Maybe because you are regulated globally also. You are not the end of things, But the regulators who have no global community or ecosystem, they don't take public participation seriously. And that's very discouraging for public intellectuals like Louis and many, but also it's also very harmful to many Ugandans, especially those who don't have access to privileged education and legal skills and knowledge and experience like what we're discussing today. These things are not very difficult. They can be made soluble to the lowest common man, even in our local languages, if the entire industry market has the discipline and aspiration to make this information publicly available before we define a common aspiration. So we should go on record that as the bar moving forward, as the radical new bar, we need to make it a priority that we must advocate for a public participation law like the one that has been presented in the Kenya Parliament, I think this month or last month, I guess, but the first reading will be this month, I believe. Louis take interest in that. Yeah, all hope is not lost. But for Uganda, the public participation were doing very badly because the judges conducted themselves with great indiscipline in the age limit decision. They played politics with a very important issue central to people's power, public participation. So we are really in darkness. And as they say, democracy dies in darkness. And without public participation, there's no transparency, there's no democratic dividend. So, but we are doing our part through R&B Live. Of course, we are trying to foster and engender public participation. There are those colleagues who think that this process is another pageantry, maybe, because that's what they used to. They think it's far beyond, it's unnecessary. But the beauty is that it's not the information is down here. Those who come later will see just how advanced, how avant-garde we were in making knowledge publicly available. I want to again move on, and in this particular regard, I want to thank Ismail for putting up your hand. Because Ismail is one of the members of the public who said, well, you people have an R&B, he put an application. So citizens are out there, businesses, which take customer responsiveness seriously, are out there. And I think Mr. Ismail Kasai was informed he belongs to that ground. Because why would we give you pride of place? There are over 30, players in the market. Why are you the only one here? You're the only one who put up your hand and said, I want to come to the R&B. Can I come to R&B? And I think you're shocked that there is no gate fee. you must be shocked. But if you have some money, some gift for the bar, for the continuance of this activity, welcome. Because others will put a gate fee to this. But thanks for coming to talk to lawyers about professional indemnity at the Radical New Bar Council, at the council level. This is just a starter, but at the council level, we shall have a bigger discussion because we want to have bespoke solutions. Professional indemnity has been a non-starter in Uganda for many reasons, one of which I want to discuss now before you come in, because it's connected to Amanyire, who has just left us. Again, apologies to our guests for the second and probably third panel, for whom I have had to interfere very unceremoniously. It's not out of disrespect, but largely out of respect for the guests we have for the fifth R&B. All of you are very special. I wanted and I appeared for this very reason, in acknowledgement and gratitude for this occasion. So Mr. Ismail Mukasa and Ms. Kashi Narwada, if you're with us, apologies. It's not out of disrespect, I repeat, but rather I wanted to present compliments, particularly to the gentlemen on the first panel before they leave. I'm told perhaps one of them has already left. Has Edward left? Ruth, has Edward left or is still around?
Unfortunately, he has left.
Okay, yeah, I really thought that I wanted to place this hopefully, but do we still have Louis Namwanja Kizito?
Yes.
Council?
Yes, we do.
Thank you. And I can still see that we have Dennis Kizito online. And I may not be fully available for the others, but I will be listening, I think. So I wanted to stress the following points very quickly, not to delay Mr. Kizito, Mr. Mukasa any further. Number one, on behalf of the Radical New Bar Governing Council, I want to present our compliments to all the facilitators for today's session because it answers squarely the purpose for why we convened the Radical New Bar Live series, as I will demonstrate later on. It also responds to Agenda R&B Vision 2060, agenda item number 4, as you know, digital transformation. And for me, when Secretariat informed me that this is the schedule for this week, I immediately, celebrated because I realized that we have now normalized, we have come to normalize what is digital, what is virtual, as just another event, in the life and blood of legal practice in Uganda. We have stripped digital, virtual conversations of the celebrity and fanfare and intricacy and technicality and pageantry that was previous associated with it, the novelty, but I liked the poster when I saw it. It showed the new faces, the new icons, the new representatives of the Uganda bar. This is a very important, high watermark for our evolution as an industry. I say this because this year we celebrate 70 years of our existence as an organized market under the terms of the Uganda Law Society Act, although legal practice had existed since 1904 when the High Court was established in Entebbe under the Orders in Council of 1902. But in all this existence, there was a certain gatekeeping and ring fencing that attended legal practice, especially green fields like these ones. But I'm happy to see that the traditional gatekeepers are not present at this occasion. The bar, the heart and soul of the bar is truly represented in those who are the bar today and who will be the bar moving forward. That is something that required me to come and stress very clearly. Because as I noticed in the last 10 or so years, conversations about these subjects have been taking place, but they have been ring-fenced and they have been attended with these unnecessary, rituals that prevented access to knowledge, as in the terms I had you, Ruth, celebrate. They were paywalled, they were registration fees, they are called symposiums, they are called conferences, annual, they are given a certain pedestal. The pedestalization of knowledge was a very, very dangerous cancer we had in our legal practice. And so we said we shall bring this information and make it open source. Another word for you, Ruth, which I'm sure, this is the language of Dennis Mwanja Kizito and his panel of the day. They are open source activists. And I wanted to come formally and register my celebration of what they believe in and what funds their passion and commitment to legal practice and shared society. So, colleagues who are Mr. Kizito, Mr. Emmanuel Amanyire, and Louis, of course. This probably is your third or fourth time here. You are prophets on a hill, holding keys to a shining castle and saying everybody belongs. You have no idea what this moment means for legal practice now and moving forward. You have no idea. Those were not the values with which lawyers thought legal knowledge should be held with. Legal knowledge, people who have knowledge that you have, hid it and kept it to themselves and get, put a lid on it, said you'll access it at an expensive fee. And they kept it mysterious and mystical. So you people are breaking ground. So that's the first thing, and I think I put it very clearly. To conclude this point, you are also developing a digital asset for the bar, this very archive. You are heroes in the sense that you're speaking to a physical audience that a traditional conference speaker would reject and walk away and say, there are no people here. let me go. It's a flop. So for you not to judge the occasion by physical attributes, but rather by digital attributes, requires commendation and encouragement. To know that some of us, miles away, are listening every word, number one, in the now live, and many other people will stream on demand, at leisure, pause, rewind later on. But above all, our children and grandchildren will have access to this archive in various formats, long form, shorts, and all media, TikTok versions, and so on and so forth. Texts and everything. They will do so much with this information that you have given the world. So your awareness to take this serious is something we must commend, because there are people who can't concentrate, who can't present and deliver, because they are seeing a very small physical audience. To speak, but anyway, the thing is, I'm speaking to the converted at the panel. You guys get it. I mean, from your presentation, you get it. You have given us a master class. I listened to Emmanuel, a fantastic envoy for the FIA. He's been generous, methodical, unrestrained, unreserved. Of course, that's Lewis's style, but also from Dennis, who didn't allow traffic jam and meetings and excuses and say, I'll be there digitally. So for you, it may seem simple, but I tell you, for those of us who have understood that it's an existential matter, it's a life or death matter, information will come by digital. We live in the digital. The digital is the now, the digital. We are digital beings. We are still few. The others who are in law firms and have wasted this time talking, and there are still many. The others, but you see, there are lawyers, non-lawyers having this open source knowledge now, and they'll have it later. So I thank you very much for that. I thank the Secretariat for taking this seriously, knowing that there are people who take it seriously, and you can't see them. You may not get feedback from them, but you still take it seriously. Some Ugandans don't have those high levels of integrity. Somebody once defined integrity as what you do, say, think when no one is watching you, when you're not aware. So the level of integrity that you're exhibiting now is commendable.